Good afternoon, ladies and gentlemen. My name is Amyn Mussa. I'm a partner at the law firm of Anjarwalla Khanna, and I head our projects, infrastructure, and real estate departments. I would like to first thank KPDA for giving us this opportunity to speak to all of you. And I would also like to thank you, the audience, for taking the time to join this webinar on a Friday afternoon, and whilst we're in the middle of very, very difficult circumstances as a result of the COVID pandemic. I will be joined in this webinar by my fellow partners, Adnan Khan and Daniel Ngumy. So the purpose of the webinar is to give you some insight of what we have seen in terms of how the pandemic has affected the real estate sector. We have broken this webinar down into 3 sections. And in the first section, we will look at the concepts of force majeure and frustration, and what do these concepts mean legally. Secondly, we will look at how the pandemic has affected commercial landlords and commercial leases, sale and purchase transactions, and lastly, construction contracts. From then, my colleagues Adnan and Daniel will then focus on the impact of the legislative and the tax changes that have arisen since the outbreak of the pandemic, and how these changes could potentially affect the real estate sector. So with that, I will move into the first topic of discussion, which we are asked all the time, which is, what is force majeure? Is the pandemic an excuse to claim force majeure? What does it mean? So I think it's very important to understand that firstly, the concept of force majeure is a civil law concept. It is not recognized in common law. What does that in itself mean? What that means is there is no implied application of the doctrine of force majeure under common law. And therefore, you cannot imply or insert force majeure into a common law governed contract if the contract does not expressly provide for force majeure. And therefore, the summary of that is, if your contract does not have an express force majeure provision, you are not entitled to claim force majeure in a jurisdiction like Kenya or England that are common law jurisdictions. Now, on the assumption that your contract has an express force majeure provision, you would need to prove certain basic principles to be able to make that claim. Firstly, you would need to prove that your inability to perform certain obligations in the contract was caused by an event that was beyond your control. Secondly, you would need to show that you could not have reasonably expected to factor this event and the impediments. And lastly, that you could not have avoided or overcome the effects. Now, whilst it would seem that the COVID pandemic would obviously meet a lot of this criteria, it is important that the specific facts of the situation are factored into, and the specific language of the force majeure clause is looked at. Because like I said, This is not a provision that you can imply or insert into a contract. So you must follow the exact wording of what your force majeure provisions say and whether you can claim force majeure under a specific contract. The second point and second concept I would like to discuss is the concept of frustration. So the question that a number of our clients say is that if common law does not recognize force majeure, what does it recognize when you have such hardship and such problems that is beyond your control? What the common law recognizes is that you can imply the doctrine of frustration into a contract, but the test and the bar for frustration and to be able to successfully claim frustration is very, very difficult. Effectively, you need to be able to show that the performance of the contract is rendered impossible due to the occurrence of an event that was beyond the control of the parties. Now, one could argue that based merely on that, we would be able to be claiming frustration on a number of contracts. But it is important to understand that the courts have gone on further to say that the mere fact that a contract has become more difficult, has become more onerous, that by itself does not allow you to claim frustration. You need to be able to show that the change is so significant that it has become impossible to perform the contract. It is not enough for you to be able to say it has become more inconvenient, it has become more expensive. It has to be a fundamental impossibility of you being able to comply with your obligations. So if you are a restaurant owner, for example, and your revenues have significantly reduced in your premises because of obviously the current situation, we do not believe that that on its own, for example, could give rise to a claim for frustration. The question could become a lot more interesting if there was a complete and total lockdown, for example, like you have in many countries, where you are now no longer even able to access your premises. So it's very important to firstly understand what these two legal principles mean before you decide whether you are able to rely on these principles to make a claim one way or the other under a contract. Having dealt with these two critical legal principles, I now want to move on to more practical issues on some of the things we have seen in dealing with various parties. The first issue, obviously, we have seen is commercial landlords and tenants having to make very difficult decisions about how to deal with the pandemic. And what I want to put across to you is some of the decision-making matrices and some of the issues that as landlords and tenants, you need to consider, practical issues that you should consider when you're making your decisions. So to go through some of these issues, which are fairly practical and commercial, but I think important to allow people to make sensible, legal, commercial decisions whether they are a tenant or whether they are a landlord. From a landlord's perspective, you probably want to understand firstly, what is the impact of the pandemic on your clients, the tenants? Can they access their premises? Is their use restricted if they can access their premises? Or are they not, in fact, impacted? For example, if you're a grocery store or a pharmacy, where it is arguable that, in fact, business is potentially up because these are considered critical areas that need to remain open even during the pandemic. The second thing is, and this links to what I discussed earlier, is does the lease have a force majeure clause? Because if the lease does not have a force majeure clause, then a tenant cannot legally claim force majeure based on the principles I just discussed earlier. Having said that, we are seeing a number of landlords make very practical and commercial decisions about how they want to deal with this, whether or not leases have express force majeure provisions. And the question they ask us is, how do we go about making these commercial decisions? And our view is the most important thing a landlord should first do is to understand that if you make any concessions to your tenant, what impact does that have on your ability to service your debt? Because that is the most fundamental question as a landlord you must ask. You then must ask, if you are able to give a rent reduction, what effect do you think it will have? Will the reduction allow the tenant to operate, or does the reduction, frankly, simply delay the inevitable? We also think the length of the term of the lease is an important consideration when you are making this decision. If you have a tenant that has 6 months left on his lease versus a tenant that has 10 years left on his lease, logically we would assume your decision-making may be quite different for those two types of tenants. On the assumption that you are able to afford concessions and structure commercial agreements with your tenants, how do you go about looking at those issues and making sure you have legally protected yourself and you have thought of all the issues you need to think about when you are structuring concessions for your tenants? So the first question is the concession in relation to rent a deferral or an abatement? What does that mean? Are you telling your tenant that for a specific period of time, if you are reducing the rent, is that rent reduction an absolute waiver, or will they have to make up for that difference when things get back to normal? So I think that is critical. The second thing is, how do you deal with the ancillary payments over and above rent? Service charge, market expenses, car park fees, etc. It is critical that you are able to get the revenue that you need to maintain your premises, to have security in place, to provide for insurance, and all the critical services that you will continue to have to provide, notwithstanding the pandemic. You will need to consider the period of the concession. Have you given tenants the same tenant's previous concessions, which then links to my earlier questions about, is this tenant's business really viable? And if the tenant is unable to fulfill its obligations, even on the reduced terms, it's critical you figure out how your termination remedies work in the event that, if, for example, you provide reduced rent, and even that reduced rent is not payable, or you insist that the full service charge is payable, but the tenant cannot make that payment, how do you deal with those eventualities? And secondly, and lastly, sorry, what other commercial agreements should you cater for if you are going to provide any concessions? Do you want additional security? Do you want personal guarantees? What kind of arrangements do you want to add on to your existing arrangements if you are prepared to provide these concessions? Having gone through that decision-making matrix for commercial landlords and tenants, I now want to move on to another decision-making matrix for sale and purchase agreements. So if you are in the middle of a sale agreement, whether you are a buyer or a seller for a piece of land, for a house, for an apartment, what potential impact can the pandemic have on your sale agreement? So the first question, which should be your primary question for every contract, is, does the agreement have a force majeure provision? And what does that force majeure provision say? If you are a seller, ideally you would not want to have a force majeure provision in a sale agreement. And if you do, ideally you would like to have an exclusion for unavailability of funds. So what does your force majeure provision say? On the assumption that you do not have a force majeure, you must also look at what conditions, what other conditions you have in your sale agreement that are conditions precedent to completion. So for example, does your sale agreement state that the buyer will conduct a due diligence between the time of signing the sale agreement and completion? Now, if, as you are aware, the land registries as of right now are not accessible, and therefore how would the buyer conduct his searches to be able to carry out his due diligence? So can the buyer use that as an excuse to terminate the sale agreement? Again, this comes down to how the condition is drafted in your sale agreement. The other condition that you need to look out for is the completion subject to the buyer getting bank finance, and can the buyer walk out on the basis that the bank has now changed its mind? So the due diligence and the bank finance conditions can have an impact on your sale agreement, even though the sale agreement may not have a force majeure provision. The other issue to think about is the completion process. So let us assume the buyer and the seller are still willing to complete the transaction. What is the impact of the closure of the registry going to have on registering the transfer, potentially registering a charge over the property if the purchaser has got bank financing? And what impact does it have on the seller receiving the purchase price if these monies are being held as stakeholder until the registration process is complete? Is there a long stop date? by which money has to be released to the seller, even if the registration process is not complete. So these are some of the issues that we think you need to look at when you are reviewing your sale and purchase agreements in the middle of this current pandemic. The last issue I will discuss on is the impact on construction contracts, the impact of the pandemic on construction contracts. So firstly, as I said, the starting point is to check if your construction contracts have a force majeure provisions. In our experience, most construction contracts have a force majeure provision. The other provisions to look out for are the change in law provisions and the variation provisions, because it is very possible that in addition to a contractor relying on the force majeure provisions, they may be able to rely on the change in law provisions and the variation provisions in the construction contracts. So it is critical to look at those three sections to understand whether the contractor has potential relief against the employer or the other way around. The other issue to consider is whether these provisions have what we call territorial limitations. What do I mean by that? So it is not unusual for a number of the construction contracts that we structure, especially where we are acting for the employer, to state that the force majeure provisions can only be affected if there is an effect within Kenya, as opposed to an offshore force majeure effect. Now, this can have a significant impact on the ability of the contractor to make arguments around overseas supply chain impacts, the ability to bring in foreign consultants to carry out commissioning and to carry out other services where there was going to be a reliance on foreign contractors and foreign consultants. In the infrastructure project space, we have seen this to be a very practical and live issue where there is a significant reliance on offshore supply chains, on offshore consultants, commissioning experts, etc. Now, on the assumption that the contractor can in fact rely on force majeure or a change in law provision or a variation provision, what remedies could potentially be utilized by the contractor? And typically, there would be three remedies available to the contractor: an extension of time, increased cost, and possibly even a termination right could be available to a contractor. So it is not unusual, for example, for a construction contract to say that in the event of a prolonged force majeure event, the contractor can claim termination of the contract. If those remedies are available, it is extremely important to understand how they work. So, for example, can a force majeure provision allow for an extension of time and costs? Sometimes it may allow only for an extension of time, but not for costs. And further, as I said, a prolonged force majeure may allow for even a termination right. So if you are allowed an extension of time, how do you calculate that extension of time? Is the contractor entitled to just 4 weeks if we have had a 4 weeks impact? Or can the contractor claim a much greater extension of time because even though the pandemic has had a 4-week impact on the project, his supply chains have had a 6-month impact. So the nature of the extension provision, whether it is a day-for-day extension or otherwise, is extremely important to understand. Also, how you calculate costs, direct costs, indirect costs, profit. It's critical for you to understand how these remedies are done. With that, I would like to come and pass on the discussion now to Adnan to explain to us what some of the legislative changes we have seen as a result of COVID and how they potentially impact you in the real estate sector. Adnan, over to you.
As I was saying earlier, we've got to thank Parliament to an extent for putting in quite a bit of time. They've probably put in and had to review quite a number of pieces of legislation in a very short time, and this legislation was required to be put in quite a quick time. So I'll be running through a couple of pieces of legislation that previously were in place that were not enacted on the basis of COVID-19, but have certain implications on the COVID-19 situation. Sorry. So we'll be looking at three sets of laws, essentially laws currently in force, but when they were brought into force, they didn't necessarily have the COVID-19 pandemic in mind. We'll then look at laws that were passed recently due to COVID-19, and then laws proposed to be passed on the basis of COVID-19. So one of the statutes that had recently been passed without necessarily on the basis of COVID-19, but seems to have a trickle-on effect on the COVID-19 situation, particularly on real estate transactions. The Business Laws Amendment Act has amended the Law of Contract Act, the Land Act, and the Land Registration Act. One of the critical points that the Business Laws Amendment Act has come into force, and a couple of law firms have recently been concerned about how do you move documents from one law firm to another to get documents signed, how do you get documents witnessed, and what have you. So the amendments that have been passed under the Business Laws Amendment Act, one of them is it actually allows for electronic signatures on conveyancing documents and recognizes such execution as valid and binding. The point to note, however, while it does cover execution of documents, it doesn't seem to cover remote witnessing of documents, and that's one of the changes we are trying to see whether we can have included either through another set of business laws amendment or through the legislation that's intended to deal with the current COVID-19 situation. Because like I mentioned, due to the social distancing measures being taken, one of the concerns is that how do lawyers in particularly witness conveyancing documents if the other party is not physically present there? It's fine enough to say that you could sign documents electronically, but witnessing of documents is a bit of an issue. The other good point that has been resolved by the Business Laws Amendment Act is the Land Act and the Land Registration Act had provisions that required the registrars to verify execution of documents by parties to a transaction. There are certain instances in which the registrar is allowed to excuse such verification processes. And the Business Laws Amendment Act also now allows a registrar to dispense with verification process where a document has been executed electronically. The Business Laws Amendment Act is also pushing for the requirement for electronic registries. This was something that had been envisaged under the Land Act. I believe what's happening, especially with the initial closure of the central registry in Nairobi, the intention is to go through a digitization process, and obviously the initial steps have been taken in order to try and implement this process. I also understand a notice has been published by the CS in charge of lands, where there is a whole tranche of rules and regulations that have been published, and they have invited comments on those with the intention of implementing a digitization process for the registries. This will essentially also help avoid having to travel to the registries, having to avoid physical contact at the registries. It will also fast track a lot of processes. The Business Laws Amendment Act has also introduced electronic stamping. While this has been introduced in statute, it's yet to be seen how this will be implemented practically. The statute came in while the central registry and the various registries have been shut. So it's going to be interesting to see how this takes place. The other change that's also coming through the Business Laws Amendment Act is the dispensing with the requirement for a fixing of the company seal. So like I mentioned, physically trying to execute documents, especially for company secretaries, where they probably have to run to the office to pick up a company seal or have a bulky thing. This would help them avoid having to travel to their offices to pick up documents, and they can simply execute documents as the company secretary electronically, and so would the director sign the document electronically. Now, moving on to the statutes that have actually come into force due to COVID-19, there are a couple of regulations and orders that have been published enacted pursuant to the Public Health Act. There are two in particular under the Public Health Act that have been enacted. That's the Public Health COVID-19 Restriction of Movement of Persons and Related Measures Rules, and the Public Health Prevention, Control, Suppression of COVID-19 Regulations. So under the Public Health Restriction of Movement of Persons Related Measures Rules, there's two critical definitions there. One is there's a definition of what a public place is. And a public place is any outdoor, indoor, enclosed, or partially enclosed area which is open to the public or any part of the public, or to which members of the public ordinarily have access, and include the workplace and a public conveyance. So, this has affected a number of places, including offices where a number of people you have more than one or two people attending the office. So that would be deemed to be a public place. You have your offices, you have your malls, you have schools involved. So all those particular places would be caught in the definition of a public place. The other definition that would also be critical under that particular rule is the definition of what a gathering is, because the rules restrict gatherings in particular instances, and a gathering could be deemed to be any grouping, assembly, crowd, procession, or any public road or space, any building, place, or premises, included wholly or partly in the open air, including any premises used for barber shop, massage parlor, beauty salon, activities, gymnasium, spa, sporting. So it's important also remember that this definition is not an exhaustive definition. So we also had an interesting query from one of our clients who manages a residential estate. And the question was whether a swimming pool meant for the use and benefit of all the residents of the estate would be deemed to be a public place, and whether therefore a gathering at that place would be permitted. And based on this thing, we had advised the client to exercise a bit of caution, because the public health rules require one to put in certain measures in place, including social distancing, sanitization, and if these measures are not put in place, you could have particularly people in, as we've recently seen in certain circumstances, especially in certain restaurants, where people have then been forced to go into quarantine based on their interaction in some of these public places. Under the public health prevention, control, and suppression rules, there have been changes put into place that, for instance, there is an obligation put in place on every owner of a particular establishment or an occupier who's managing a particular place to inform the medical officers, practitioners, or a health facility if they suspect any person who is residing or occupying a particular premises who is suspected of having COVID-19. The other point under that is also the public health officers, the medical officers have now been given the powers to restrict access to particular buildings that they suspect there may be contamination, or restrict getting out of a building for that purposes. The other statute that did come into force, obviously, which should have come before the other one, which is the Public Order State Curfew Order. This is the order which essentially set in the curfew times of 7 p.m. to 5 a.m. And the same order also sets out the essential service providers. And it's critical for those who are the essential service providers who are exempt out of that. As Amyn had earlier mentioned under his presentation on force majeure and frustration, one of the common reasons for the application for force majeure or frustration has been that due to the public order and the Public Health Act restrictions that have been put place, certain individuals have not been able to access the facilities, and therefore they should be entitled to claim force majeure or to claim frustration. But the consequences and the tests for force majeure and frustration have already been discussed by Amyn on that. The other recent regulations that did come into force, and I think to the relief or to the stress of a number of restaurants and eatery operators, was the protocols for management of restaurants and eateries. So this reviewed the earlier restrictions of operations and eateries. The protocols now seem to provide for additional requirements on how food delivery will be done, how the cooking and management of the restaurants will be done, the testing of health workers will be done. As you could recently see, there was concern by a number of these operators as to who would bear the cost and how regular this testing will be done has also come into question on this. So a number of restaurants who are operating are having to put in place screening, hygiene measures, and social distancing. So it's going to be interesting to see how this particularly impacts the restaurants and eateries, particularly in terms of, one, as we understand, they have been affected by one, which is the attendance or people actually going to their physical premises to have a meal. And two, as we understand, a number of restaurants have also been affected by deliveries and takeaways and have simply shut shop. There are a number of eateries who seem to be enjoying certain food movement, thanks in line also with the online and digitization with the various online platforms. The other amendments that have come in is the Tax Laws Amendment Act, but I'll let my partner Daniel touch on that in the presentation later. There are a number of other proposed legislations that have come into the limelight. One is the Pandemic Response Management Bill, popularly known as the Sakaja Bill. That has amendments to a number of legislations or proposals to a number of actions that need to be taken in line of the COVID-19. As I mentioned earlier, the CES has also requested for public participation and comments on a number of legislation intended to implement the digitization and electronic implementation of the registries. So that's the land registration regulations. The NCA has also recently published the standards for management of construction sites and welfare of workers. There had been a bit of confusion on this particular guideline where a number of people had thought this had come into force and had mandatory provisions that were applicable to all construction sites. So we've been interacting with the NCA, thanks in line with the KPDA and a number of other professional bodies as well. And what we understand is the NCA, the guidelines that they've prepared were initially envisaged to be guidelines as a best in practice guidelines to take into consideration the current COVID-19 situation. They are still taking in comments and recommendations and suggestions from various professional bodies, including KPDA and law firms. So just to keep in mind that the guidelines have not been gone through the process set out under the Statutory Instruments Act and have not been published under the Kenya Gazette. So they do not have statutory effect, which is something we are currently discussing with the NCA and see how that will be implemented, and if it is implemented, how that will be enforced. Just otherwise, other than that, having taken into effect the other than the legislative effects on the COVID-19 situation, a number of practical situations touching on the land transactions. For instance, under the Land Control Act, where there's a transaction involving agricultural land, you are required to go to the relevant land control board to procure the consent for that particular transaction. That particular process has been affected by the COVID-19 situation and the current geographical lockdowns that we have in place. Certain payments for rent and rates has been affected at the various local authorities, and payments to be made to various other government offices has also been affected. So one of the things to probably look at is maybe digitizing the process, which a number of government authorities have, or adopting online payment platforms. As was also mentioned by Amyn earlier, the closure of the registries. So the central registry in Nairobi had been shut since February this year. And there have been subsequent notices of closure for all the other registries from March 16th. And as we understand, there was another notice that was issued earlier this week for further closure of weeks. While there is a closure, the notice also states that the registry is still accepting documents being lodged for purposes of processing finance-related transactions, and any court order-related documents. So those are just the matters that we are looking at currently, and the live transactions and practical issues I look at. I will hand over to Daniel to touch on the tax side.
Thank you very much, Adnan. Let me just share my screen. Great. So I will quickly run through the tax issues that have come through, and I will emphasize in particular the issues that pertain to the real estate sector, and which touch specifically in respect of the matters that we have been talking about today. There have been a lot of interesting changes. The first thing that the president did on 25th of March 2020, he announced a number of measures designed to cushion Kenyans from the impact of COVID-19. Now, as soon as COVID-19 came in, there have been an outcry about the need to cushion Kenyans on the tax impact. In particular, there had been a number of issues and countries that had been implementing changes. So the president was under pressure, and he felt on behalf of the government that something has to be done in order to demonstrate that the country is taking steps to cushion Kenyans from the full impact of COVID-19. Almost immediately following the 25th of March announcement, on 1st of April, through an amendment that was gazetted by the Cabinet Secretary for the National Treasury, the VAT rate changed from 16% to 14%. That did not need a parliamentary approval because under the provisions of the VAT Act, the CS has the powers to be able to enact such a reduction in the VAT rate, and he implemented it almost immediately. It was effective 5 days later. The president also indicated that there would be VAT refunds of approximately 10 billion to be released by the KRA immediately. To the best of my knowledge, that is still work in progress. I haven't heard of the Kenyan government being able to implement it. So we will wait to see how soon that can be implemented in the coming days. The interesting thing, though, is that part of what the president had indicated needed to go through the parliament was supposed to be some changes in PAYE, which I'm coming to. And it was supposed to be issued through the Tax Laws Amendment Bill. Why I'm saying that it is interesting is because when the Tax Laws Amendment Bill came out, we realized that it did not just touch on COVID changes, but there was a whole raft of changes that touched on a number of other things, which you will see in the next slides that were introduced. So beginning with the issue of PAYE, that has given a lot of relief to Kenyans in general. By now, most of you know that the PAYE rate was reduced from the top rate, was essentially reduced from 30% to 25%, as is the case with the corporation tax rate through the Tax Laws Amendment Act. And anyone who earns less than 24,000 shillings a month is no longer subject to any form of PAYE due to the tax exemptions that have been given. Unfortunately, what the government gave with one hand, it took away with the other, because there was a repeal of the second schedule of the Income Tax Act. Now, this is particularly important for members of KPDA to note, because in reality, it touches on a number of things that are important to you. For one, in the older days, hotel buildings could obtain 100% upfront investment deduction in the first year. It has been reduced to 50%. Buildings that could previously obtain for use of manufacture 150 and 100% allowance in the first year, that exemption has gone away. Hospital buildings, previously there was a bit of lack of clarity. Were they eligible to 100% or not? Those have received 50%. In the old days, they would have received 100%. Educational buildings, including student hostels, the relief or the capital allowance that was previously much higher has now come to 10% per annum, down from 50% in the first year. And commercial buildings, which could receive 25% per annum, spread over 4 years so that you could get 100%, has now gone down to 10% per annum. The effect of this is that investments, new investments in the real estate sector will no longer enjoy the substantial capital allowances or investment deductions that were applicable in the first year, and those have now been spread across over a number of years. What this means in particular for example, for commercial buildings, is that it is possible going forward for developers to find themselves in the first, second, or third year of their project becoming taxable. In the older days, it would have taken quite a longer period of time because the allowance would have been all received within the first 4 years of the life of the project. Another thing that has happened, and this is particularly important for structuring purposes, VAT on transfer of business as a going concern, that exemption has been removed. Now, this exemption was extremely important for purposes of structuring the manner in which a rental business could be transferred in one go from one entity to another. To give you a practical example, if a potential purchaser indicated, I intend to acquire 5 or 6 buildings, commercial buildings, held by one company in one go as part of a rental business, the transfer of that entire business at one go would probably have been subjected to or available to enjoy the transfer of business as a going concern exemption, which would have allowed them to be transferred from the seller to the purchaser without the payment of VAT. If you sell a commercial building, most of you are aware, there is VAT that would arise at the relevant rate at the time. Previously it was 16%, it is now 14%. The removal of this exemption will impact the ability of a seller who seeks to sell his entire rental business portfolio in one go, because that exemption is no longer available. It is something to note because it applies not just to the rental businesses, but also to a number of other businesses in Kenya and commercial enterprises that will be seeking to transfer business as a going concern. Important to note, the VAT exemption relating to the transfer of assets into a REIT has been removed. It is extremely surprising for us because this exemption was introduced not so long ago. I think it was introduced in 2018. So it has not lasted more than 2 years before it has gone out. The other thing, on the positive side, pension scheme funds can now be utilized to purchase residential houses. The regulations, the draft regulations were only released this week. So they still work in progress, and the National Treasury has welcomed comments with respect to these guidelines that have now been issued. Moving on, and I apologize that I am rushing through quickly because I'm only highlighting the most salient issues that pertain to the real estate sector. But moving on, the Finance Bill, hot on the heels of the Tax Laws Amendment Act, which was only passed towards the late end of April, and the Finance Bill 2020 has now been published. It was published this week on the 5th of May, and it also introduces new changes in tax. It sets to increase various tax bases, and has sought to introduce new taxes, and there are a number of proposals to remove certain exemptions that have also been introduced or are proposed to be introduced to the Finance Bill. Our law firm is actually going to be issuing, in the course of either today or early next week, an analysis of the Finance Bill, and we shall share that across to you for purposes of ensuring that you all see the changes that are coming through in detail. But having said so, I just want to touch on the main proposals that have been proposed in the Finance Bill, and which are going to be relevant to members of KPDA. The first thing to note is that the minimum tax has been introduced, or has been proposed to be introduced, at the rate of 1% of the turnover of a person. Now, this is a law that exists in a number of East African countries. The law currently exists in Rwanda, it exists in Tanzania, I understand it also exists in Mozambique. And what it essentially provides for is that whether a company is in a loss-making position, whether it is enjoying an investment deduction, or whether it is currently in a state where it has an unutilized commercial building allowances, among other things, it will be required to pay a minimum tax of 1% based on the turnover of that entity. Now, to give you a practical example, there are companies which enjoy reliefs. So, for example, if you have just built a commercial building and you're in the first early stages of the construction, post-construction, you will be in a loss-making position. The provision now requires that regardless of the fact that you're in a loss-making position, a minimum tax of 1% will be payable on the turnover that has been made in the course of that year. This means that the effective tax shield that has been currently being enjoyed will not be fully available if this tax law comes into force as has been proposed in the law. The flip side is that companies or individuals, landlords, who have rental income, which is currently taxed at 10%, will enjoy a higher threshold of the rental income that can be subjected to residential rental income at 10%. Important things to note: this is only available to residential rental income. It is not applicable to commercial rent. The second thing to note is that previously you could only enjoy this to the extent that the rental income did not exceed 10 million shillings in a year. There is some relief in the sense that that limit has now been proposed to be increased from 10 million to 15 million, meaning that more people can then fall into the bracket of residential rental income. And the real benefit for this is that having paid 10% of your turnover, there is no longer, there is no further requirement for you to pay any additional taxes in respect of that income to the extent that the property is held by an individual person. Obviously, if the property is held in the name of, in a corporate entity such as a company, there will be a dividend withholding tax that applies on the extraction of that revenue at the time of making the payment of dividend. So this is an interesting new change, which will be beneficial to landlords who own residential income, but it is important to bear it in context of the fact that it is an increase of the threshold for people who are currently enjoying this relief. There are a number of other issues to consider. For example, there is a proposal to remove the tax deductions allowed in respect to contributions to a registered home ownership savings scheme. And the reason why this is particularly puzzling is because it had previously, it essentially goes against the grain of what the president has been saying with respect to his Big Four agenda, and in particular, enabling homeowners to acquire homes over the next few years. It is also very interesting to note that the Tax Laws Amendment Bill proposed to delete this provision. Parliament debated and said that it goes against what the president wishes to do with the Big Four agenda. So Parliament reintroduced it back into the laws of Kenya. And now the finance bill seeks to take it away, all within a period of 1 month. So we're not sure what is going on here, whether there's a tussle between the law, the Parliament in the process of making or enacting its laws, vis-a-vis the various people in the the policy makers in National Treasury, but it is quite interesting to note that the proposal seeks to remove that tax deduction, which is otherwise available for first-time homeowners under the scheme that has been created in the tax laws. We will wait to see what Parliament will do, given the fact that it had only recently taken it away. The other thing to bear in mind is is the expenditure incurred on the construction of social infrastructure, such as public schools, hospitals and roads. That will not be allowable anymore as an allowable reduction if the finance bill comes through. And finally, two other things to bear in mind is that many of you may have encountered this. There is VAA, which currently exists, where they are requiring a matching of input VAT versus output VAT. It has been sought to be legitimized through the finance bill. Currently, the Kenya Revenue Authority has been applying it through regulations that they have introduced they themselves. But when we look at what is currently being proposed, it appears that for all intents and purposes, this is going to be legitimized in the law through the finance bill. And finally, the finance bill proposes an introduction of a voluntary disclosure scheme, where it's almost for all intents and purposes going to be a sort of if you report yourself to the Revenue Authority, it's a disclosure scheme, and you indicate the taxes that you have not been remitting. For all intents and purposes, you will get waiver, a full waiver of penalties and interests, and only the principal tax will be payable. So this is mainly a highlight of the new changes that have been proposed through the finance bill. The tax amendment laws have already come into force. And as I have said, we will be following this up with a bulletin on the significant changes that are coming through the finance bill. And anyone who has any other questions, we're happy to take them now. Thank you, Adnan. Handing over to you in terms of moderating the Q&A.
Thanks, Dan. So we've got quite a bit of queries and comments coming through. So I'll just try and share this with you. So I'll run through the ones in the chat before we go through the ones sent on the Q&A. Questions come through. Where the landlord has given various concessions on rent, either rent reduction or deferred rent, does it require an addendum to the main lease, or is a letter signed by both parties adequate towards ensuring the terms of lease remain, and also for audits such as conducted by KRA? This is a question from Sophia Mwani.
Yeah, it's a very real and practical question that all our landlord clients have asked us. From a strictly legal perspective, you require a deed of variation that needs to be stamped and registered at the lands registry. That is the strict legal requirement. Having said that, because of the closures of the registries, because people are cost conscious, we have seen a number of people resorting to using letters, but in an appropriate format that meets certain requirements of the Law of Contract Act, to try and mitigate the risk of not fully following the requirements that I have just set out. So, like I said, there is a strict legal requirement, but currently that legal requirement is impossible to meet. So practical solutions are being looked at to see how this can be dealt with.
I mean, just to add there as well, I think one of the other points that has been raised in terms of having a document for signing is, and one of the complaints landlords have had, unfortunately, for us lawyers, is that if you do have to prepare a document, there's legal fees involved. And how do you see that cost in terms of, especially when you're giving rent concessions, and who bears that cost? So that's another point that is considered during this time. Another question that's also come on, sorry, I think that's on the Q&A. Sorry, so there's one question that's come from Gikonyo, KPDA, and the question is that with the enactment of the Land Acts, the Land Control Act was repealed. So Gikonyo, just on that particular question, it was initially envisaged that the Land Control Act was supposed to be repealed by the whole land amendments that were coming through in 2012. They had also incorporated some of those provisions in the draft bills, but at some point in time, before the bills were passed into law, the provisions on the Land Control Act were removed out of the land legislations. And when you look at the memorandum at the end of those pieces of legislation that refer to the statutes that they repealed, the Land Control Act was not there. There's also some bit of query on the status of the Land Control Act, but that is something we are looking into. And by the way, to all the participants, in case we are not able to answer your questions before, we only have about 13 minutes remaining. In case we're not able to answer your questions, we'll try and respond to them on email. So, Amyn, I think this may be another one for you as well. So there's a question from Stella Mutai. How do banks handle undertakings where clients have lost income, are on pay cuts or unpaid leave, and their transactions were going through conveyancing?
Well, in fact, that's a very interesting question, because there are a raft of issues that are impacting bank facilities and possibly undertakings specifically. So if the bank has given an unconditional undertaking to pay upon the occurrence of a certain event, then they are legally obliged to pay under that undertaking. But remember, if one of those requirements is the registration of the charge and the transfer, and you are unable to register the charge and the transfer because the land registry is closed, the bank may be able to use that condition rather than a default or a breach under the loan agreement to get out of its undertaking. So it's a very interesting issue that depends primarily on how the undertaking has been drafted and how the registration obligations can be impacted.
Amyn, I think this is in relation to the contracts, which is, do you see FM provisions becoming standard clauses going forward following the experience with COVID-19?
So I guess my starting point to that is a force majeure provision should never be looked at as a standard provision. But I do accept that going forward, whether it's on sale and purchase agreements, whether it is on lease agreements, construction agreements, and a whole host of commercial contracts, we will be seeing a significant negotiation on force majeure provisions and how each party will deal with those provisions depending on the potential impact on them. So I think people have become certainly alive to the whole concept of force majeure. So it will certainly be a very interesting new discussion on almost every single new contract going forward.
Okay. And Dan, just one, I guess we'll just wrap up one question because we've not touched on the tax one. Dan, there's a question that's come through and asking, do you see, in light of these concessions or reliefs that the government has tried to give, do you see any other option in terms of recovering funds or other additional taxes that may be imposed on the citizens in order to recover some of the concessions given in light of the budget deficit that Kenya is already going through?
Yeah, I think, to be very honest with you, I think it's inevitable that there'll be more tax paying. You know, when you look at the finance bill has recovered quite a bit of the taxes the government was going to lose through the concessions. Almost all the exemptions are now gone. And the practical issue is that the government will continue to try to, you know, to recover the taxes. I think in two ways. First of all, through the change of law, but secondly, through enhanced audits and much more vigorous tax assessments that the government is going to be raising. So this is the time when, you know, everybody needs to sort of clean up their books. When that voluntary disclosure comes through, many people may want to consider taking it, because you're better off paying the principal taxes and having the penalties and interests waived than facing a full-blown tax assessment, which will be what is likely to happen over the next couple of years.
Yeah. Thanks, Daniel. I absolutely have to wrap it. Oliver's killing me about time. So thanks everyone. Thanks Amyn, thanks Daniel. Thanks everyone for taking your time out to attend the webinar. In case you have any queries, we will be sharing our email addresses, and we're reachable on phone as well in case of any other queries. We've got the questions that are still pending. For those whom we've not answered your questions, please do share your email addresses with the panelists, and we will get back to you on your questions.
And I would just like to add, thank you, KPDA, for putting this together.
Thank you very much. Thank you.
Thank you.
Thank you.
Bye.